Okay, I think we are online.
We are.
Okay. So, good evening, everyone. Welcome to the fifth lecture on emergent issues in international commercial arbitration. This lecture is now, this session of this lecture is organized by the Center for Alternative Dispute Resolution, Jindal Global Law School, and the Jeju Investment Society. So today we have with us Mr. Pranav Magu. Pranav is the CEO of ELF Partners, and he's also the former South Asia head of the Singapore International Arbitration Center. So Pranav is a 2010 graduate of Amity Law School. He joined SIAC in 2015, and he was based in Mumbai office. Prior to that, he was working with Clifford Chance, which, as you know, is a British Magic Circle law firm. So the topic that we have today is litigation financing. This is a very interesting topic because, as you know, this is something has been anathema to us for a very long time. Because when we studied law, we were taught that any kind of sponsorship of a litigation constitutes sham party, and it was treated as a moral as well as a legal offense, right? However, presently, if you see that if there is no background finance available for litigation, then you might have a situation where many worthy claims will not be pursued, or people are going to be hesitant to enforce their rights because lack of support, lack of access. So litigation financing at one from one perspective is an access to that it enhances people's access to justice. From one perspective, it adds value at various levels. And from the student's point of view, it is also a very up and coming career option because, as you know, the whole world is changing, the litigation is changing, and the world, the commercial world that you will enter would be very different from what we did, right? So, without much ado, I give the floor to Pranav. Pranav, if you can start the lecture.
Thanks, Subrajyoti. Hi, everybody, and thank you for that introduction. But I thought that I would start by introducing myself, but thank you for that. Just reduces one point that I had in my list of what all we will discuss today. However, I will just say a line or two about myself. So, as Subrajyoti mentioned, I had started my career with Clifford Chance in Singapore, practicing with the international arbitration team. I had the opportunity to act as counsel for a number of SIEC, ICC, LCIA, LMAA, and even ICSID arbitrations. So that gave me a good insight into the arbitration world. Post Clifford Chance, I joined the Singapore International Arbitration Center. I was heading the South Asia desk for them. I was based in Mumbai. And it was, let's say, pretty much my job to educate the market about the nuances of litigation, about institutional arbitration, and of course, by extension, SIAC. So I have been someone who has been closely associated with the international arbitration community and with the international arbitration world. And that's how I forayed into litigation finance, and which brings me to today's topic, which is the prospects of litigation finance in India with special reference to international commercial arbitration. What I would like to do today is that I would like to speak about, yes, the theoretical aspects, but also examine the practical aspects of litigation finance, how it has evolved over a period of time, where can we find its roots, and how can we trace its roots in India. And of course, I would request that we'll keep this interactive, we'll examine this together. So in case you do have any questions, please feel free to ask me as and when. Right, so that brings us to the introduction to litigation finance and third-party funding. As the name suggests, third-party funding is funding of the litigation costs by a party which is not related to the litigation. It's a third party. I'd like to quote here the definition of third-party funding as per the report of the International Council of Commercial Arbitration, for short ICCA, and the Queen Mary Task Force, which says the term third-party funding refers to an agreement by an entity that is not a party to a dispute to provide to a party, an affiliate of that party, or a law firm representing that party A funds or other material support in order to finance part or all of the cost proceedings, either individually or as part of a specific range of cases. And B, such support or financing is either provided in exchange for remuneration or reimbursement that is wholly or partially dependent on the outcome of the dispute, or provided through a grant or in return for a premium payment. Let's just simplify this. Simply put, third party funding is the process by which an unrelated party, a third party, to a dispute agrees to pay whole or part of the cost to contest the litigation, with an aim to make a profit from the proceeds of such litigation. For a third party funder, it is an investment in a worthy claim that can generate a profitable return on investment from the amount of the award or settlement, so as the case concludes. Going back, I would like to stress upon two terms that I used right now in the simpler definition, which I paraphrased, is that a third party funder is making an investment. Prior to that, I had mentioned that it is an investment made for a profit. Simply put, it is a business. While it does definitely serve a very noble cause, that it definitely increases access to justice. It levels the playing field, so as to say, it enables a party or a claimant to pursue its litigation with top counsel and not worry about the cost. So it does serve a noble purpose, but at the same time, it is an investment which is being made to earn a profit. So it is indeed a business for profit. Now, how do these third-party funders make a profit? Again, as simply put, and also by the definition, it is simply that I am going to agree to fund part of the litigation cost or all of the litigation costs in exchange for certain part, percentage, or a multiplier on my investment. Once an award or an order or a judgment is enforced and amounts are realized, that is when actually a third party funding agreement comes to its conclusion, only on realization. I mentioned the term investment a couple of times, so I will just slightly go into the process of litigation finance and how third party funders look at a case. Now, they are looking at a case as an investment opportunity. Whether it's a viable investment opportunity or not, it depends on the due diligence of the case. Now, here we are talking about a new asset class which is being formed, which is litigation cases. In fact, certain reports suggest that it is one of the highest performing asset classes in the UK for the past 10 years. However, when any investor, even if it is an individual investor, even if it is just you and me, if we are making an investment, we try to do our due diligence. Here, the investment is into a litigation, so the due diligence has to be done accordingly. We have narrowed it down to three core parameters which third-party funders look for in a case. Number one is the legal merits. As the name suggests, it is an analysis that how strong is the case legally, how strong is the case on law, how strong is the evidence, what is the strategy which counsel are proposing to pursue, or if it's an ongoing case, then of course, what is the strategy which has been used so far, what are the steps forward, basically how strong you are on legal merits. Second is quantum analysis. Quantum analysis is something which has become a very important aspect of international commercial arbitration in itself. And of course, I think so now even Indian courts have started using experts for their opinions on quantum, on damages, and such kind of analysis. So as the name suggests, quantum analysis is that when a claimant is claiming, let's assume $100 million, is the claim actually $100 million or not, is done by forensic accountants, is done by experts in the field who analyze the entire loss, who analyze the entire case, and analyze the quantum based on the accounts, based on the market conditions, and give an accurate number which counsel is able to prove in front of a tribunal or in front of court. At the same time, a quantum analysis can also reveal whether a claim which the claimant is saying is worth $100 million might just be above $200 million, or at the same time, it might just have been escalated from $10 million to $100 million. Third is sorry, just a second. I believe there is an echo. Please let me know if it's better or if my voice is unclear. Am I audible to everybody?
No, there's some disturbance from the backside. No?
I'm not too sure. Why is that? Right. I'll continue. In case it gets unbearable, or in case I'm not audible at all, please stop me and let me know. Coming back to an investment and coming back to the three core parameters that I was talking about for an investor, for a third-party funder looking into the case, I just explained quantum analysis. The third one is what we loosely term as asset tracing. As the name suggests, it is tracing the assets of a respondent in order to determine if the other side is good for that claim or not. So basically, you might win the arbitration, you might get the award worth $100 million, for example. But if the other side is bankrupt and they don't have assets worth $100 million, then it just becomes a paper award. It is extremely important for an investor to know where those assets are located, if after being successful, he would be able to realize his amounts which would be owed to him as per the arbitration funding agreement and of course as per the award, and where those assets are located. Why? Because execution is a very important step. Again, for an investor, he needs to know in which jurisdiction he would be filing for execution, how easy or difficult it would be to execute the award. So the analysis which is done on the presumption that this case is going to run its entire length and breadth, the entire course, and what would be the costs. Now then there is a budget which is prepared keeping counsel in mind, keeping what kind of team needs to be constituted and how long the case will run. Once the budget is approved, a funder gives his terms, and of course the parties are free to negotiate on the finer aspects of the agreement, of the funding agreement. Usually a funder expects a return which would be 3x or 4x of his investment. So basically he's looking to at least triple to quadruple his initial investment, thus making it a high risk, high return form of an investment. Why high risk? Funding agreements are done on a non-recourse basis. Non-recourse means that in case the case is not won, in case the claimant loses, the claimant is backed by the funder, the claimant is not liable to pay the funder back his initial cost which he has invested. So typically, this is how litigation funding works, and this is what litigation funding is, terming it very, very loosely. Important points to take from this are that, yes, as I suggested, it does serve a very noble purpose. It does serve a very noble cause in leveling the playing field. But at the same time, it is important to remember that this is a business done for profit. It's an investment which is done for profit. Speaking about and coming to the topic at hand today, which is examining the prospects of litigation finance in India. First and foremost, what I'm going to very briefly try and do is speak about the history of litigation finance in India and how it can be traced to way back in 1876. A lot has now, fortunately for people like me who are trying to educate the market on litigation finance, a lot has been written on this now. And quite a few surprising things come out of this research. First and foremost, like I said, the roots of litigation finance in India can be traced to way back in 1876, where a judgment passed by the Privy Council in the case of Ram Kumar Kundu versus Chandrakanta Mukherjee held that the doctrines of champity and maintenance were laws specifically designed for England to prevent the perverse practice of judicial officers oppressing the king's subject by maintaining vexatious suits or purchasing rights and litigation. It also went on to hold that the doctrine of champity and maintenance are not applicable in India, and champitous contracts can be struck down only if the object is contrary to public policy, a term which has been used in the arbitration field a lot, public policy and contrary to public policy. We will be talking about that. Going forward, there is another judgment which was in, I think so, in the year 1952. If just a second, I'm just going to indicate notes. Yes, it was in the matter of Mr. G, a senior advocate of the Supreme Court. This again examined litigation finance in the sense that I believe this was a case in which contingency fee arrangements between lawyers and clients were examined for the first time. Post that, and in relation to that, the court also examined if a third party can fund a litigation when he is not counsel, he is not a counsel, and he is not an advocate as per the Advocates Act. Also, we can trace the roots of litigation finance in the Civil Procedure Code. The Civil Procedure Code in Order 25, Rule 1, which is on the subject of security for costs, has certain state amendments dating way back to 1950s, then 1960s, and I think so the last one was in the 1980s. State amendments done by state of Maharashtra, Gujarat, Madhya Pradesh, where specifically words were added to state. I would like to quote that actually. Power to impede and demand security from a third person financing the litigation. By way of state amendments to Order 25, Maharashtra, Gujarat, and Madhya Pradesh have added to Rule 1 as well as Rule 3. And these specific words do indicate that the concept of litigation finance in India is not alien. It is something which has existed for a number of years and for a number of decades. It is also amazing that it has been examined and included in the statute itself, in Civil Procedure Code. As I mentioned clearly, there is enough evidence and there are clear words under Order 25, which suggests that litigation finance in India has been examined, or at least there does exist this concept. Now, coming to more recent pronouncements by the Supreme Court in the case of A.K. Balaji versus in the case of A.K. Balaji, the Supreme Court held that third-party funding there is nothing against it as long as it is not a lawyer who is financing the litigation. So contingency fee arrangements are definitely something which is not allowed in India. However, there doesn't seem to be any statute or any prohibition on a third party, unrelated party, funding the litigation costs for profit. Also, certain cases are currently pending which would examine the concept of the application of public policy, whether such arrangements are against the public policy of India or not. There is a case which is pending in the Bombay High Court. In fact, there are a couple of cases pending in the Bombay High Court. Just going to quote those cases. SR is currently in the Bombay High Court, where it has been resisting a Section 9 application. It is a very, very popular case which actually emanates from an ICC arbitration and has already been adjudicated upon by the arbitrator in the UK, as well as the UK High Court, where in that particular case, arbitrator awarded cost for litigation finance as well. So if you go back, and I told you that in the litigation funding deals, typically the funder is looking to take about 25 to 35% of the recoveries or making 3x to 4x on his investment. In that particular case, the arbitrator went ahead and even awarded that extra part to the claimant in order to pay the litigation funders. Thus, costs of litigation funders were also included in the arbitral award. This was examined in the UK High Court on the basis that has the arbitrator exceeded his power in awarding those costs. And as per the UK Arbitration Act, it has been held that no, the arbitrator has the power to award costs which are related to the litigation, which are related to the arbitration, and such other costs would also include the cost of litigation finances. There is also another case, which again, the Bombay High Court, I believe, has already given a judgment on and is currently pending in the Supreme Court. And I will just give you the name of that case. It's Jaiswal Ashoka Infrastructures versus Pansare Rawat Salakar. Very interesting case on contingency fee arrangements, as well as examining the concept of third-party funding. In this particular case, a chartered accountant represented a party in an arbitration as their counsel and had a contingency fee arrangement with the client. He was successful in the arbitration. The clients were successful in the arbitration. However, post the arbitration, the clients refused to pay him as per the agreed fee arrangements, and it has been contested that such kind of contingency fee arrangement or damage-based agreements, also they're called, whether they are allowed in India or not. In that particular case, the Bombay High Court has already delivered this judgment stating that since the individual in question is a chartered accountant and not a lawyer, and as registered under the Bar Council, and the Advocates Act would not apply. However, it would be very interesting to see what the Supreme Court holds, in which it has already made Bar Council a party and has asked the Bar Council to file its affidavit. It would be very interesting if the Supreme Court goes into examining not only contingency fee arrangements, but also where third parties are involved. As the Bombay High Court in this particular case clearly has taken the stance that since it is not a lawyer, the person is allowed to enter into a contingency fee arrangement as well, which typically is third-party funding or somewhat third-party funding, where a lawyer is not representing the client. Speaking about evolution of third-party funding, I already mentioned that it was a doctrine of championship and maintenance, which has always been, let's say, which has always provided that has been that hindrance to third-party funding and litigation finance. In fact, in certain countries, even now, for example, Ireland, even now considers third-party funding arrangements to be, I think so, a crime as well as a tort. The evolution of third-party funding can be seen in, and I will just stick to Asia. So it's a very recent evolution in Asia, where Singapore introduced specific regulations for third-party funding in the year 2017. Hong Kong followed and also issued specific regulations for third-party funding in the year 2017. However, Hong Kong is slightly different, that it has now gone ahead and even issued a code for funders, which I believe came out in the year 2019. There are the funders which are operating in Hong Kong or cases related to Hong Kong seated arbitrations have to abide by that code. Singapore, on the other hand, as I mentioned, has certain regulations. As Singapore has been, a very successful place in Asian jurisdictions for arbitration, it leads the way for other countries and other jurisdictions in Asia to follow. It has placed itself as a hub for international arbitration. Thus, every related development with arbitration, it tends to catch on to other jurisdictions. For example, definitely the neighboring jurisdictions like Malaysia, like Indonesia, like Thailand, and of course, Hong Kong and India. Singapore allowed third-party funding in arbitration and arbitration-related court litigation. It has very recently, just earlier this year, further gone ahead and amended the rules now to even include domestic arbitration as well as Singapore International Commercial Court cases, SICC court cases. Also for insolvency proceedings. So I see there is a comment or a question. So I see a comment from Sinhani, and I'll just answer that right away. I have already mentioned that this is done on a non-recourse basis. So when a party loses, they are not liable to pay back the litigation finances. That's why it is a high risk, high reward kind of an investment, because the financier, the litigation funder, is taking and assuming all risk associated with the case. So in case they do go ahead and lose the case, lose the claim, all the costs which has been funded, all the costs which has been incurred would be a loss to the financier, and the claimant would not be liable to pay back the financier in that case. Yeah, so I was talking about Singapore and how it has now allowed domestic arbitration as SICC to be funded. However, the entire spectrum, so that means that it is third party now is limited to arbitration, arbitration related court litigation, domestic arbitration, SICC cases, as well as insolvency proceedings. It's very interesting to note that in India, no such restriction even now. Further development has also been happening in India. We now see litigation funders which have just made an intake into the market. Also, global funders are looking at India very, very closely. There has been the formation of IALF, which is an Indian Association of Litigation Funders, primarily to promote litigation finance, like any new development. And so I just took you through the history. So it's not really a new development, but because Singapore and Hong Kong have been recent additions or have recently adopted third-party funding, we are considering it as a new development. And probably that is the reason that now everybody wants to examine the prospects of litigation funding in India, how it can grow, what are the laws, and how it can be implemented into a new industry and an asset class. I'm sorry, am I audible now? I hope my voice is clear.
I'm sorry, voice is not clear. Some disturbance in the back,
Can't hear you properly, Pranav.
Pranav, I think the problem is actually with the internet. So it's nothing on your end you might be able to do. Except that if you have any phone or electronic gadgets nearby, you can remove it and you can switch off the speaker. I think that's the only thing on your end that you can do, maybe.
Yeah, this was clear.
Sorry, I have removed every electronic. So am I clear now? Is it better?
Yeah, I mean, please continue. So just speak in a slightly loud voice, and that's it. I mean, that's
Sure,
it.
I'll try my best. Okay. Before I proceed, I do see another comment and another question. So let me take this one from Nagraj. Mechanisms, if any, for setting up an institutional fund for raising capital to invest in arbitration financing. How does the business model from LCM work? So thank you, Nagraj. Clearly, you do know a bit about arbitration financing and litigation financing. LCM, as you mentioned in your comment, is a global funder. It stands for Litigation Capital Management. It is a funder which is based in Australia but is listed in London. Now, these are specialist funds which have been existing. So when Australia allowed third-party funding in 2006, there was an influx of funders there. And LCM, I believe, is one of the oldest funders there. They have been set up specifically to invest in arbitration-related litigations. How they have raised funds is that they do have shareholders who have specifically invested for this particular purpose. I had mentioned right at the very beginning and giving the introduction on litigation finance, how it has developed as an asset class and is one of the highest performing asset classes in the UK. So there are investors which are big funds, big PEs, big VCs. For example, the Elliott Group does back a litigation financier, which is called Innsworth. So there are investors like that as well. A very popular or rather very known third-party funder in UK is Augusta Ventures, which again, Augusta Litigation Finance is a litigation financing arm of Augusta Ventures, which of course has a portfolio of investments. What makes an LCM, and of course, most of these funders are listed. For example, Burford, one of the biggest litigation financiers in the world, is a US-based funder. Since they are listed, they become liable to their shareholders. They have to declare the amounts. They have to declare how much of amounts are invested, what kind of returns have been provided. So the disclosure provisions basically exist. LCM is not a funding arm for any particular funder. So it is specifically been, let's say it has specifically been established to only finance litigation cases, and they raise money from institutional investors, such like, in fact, it was, I think, so reported as well, I believe Goldman Sachs, where they, LCM raised about 175 million only to invest in a particular sector of disputes as well. Similarly, in fact, that brings me to another very interesting development, which is happening in other parts of the world. Funders are now entering into financial agreements with law firms. So, for example, Boyce Schiller recently entered into an agreement with a funder to fund all their cases which are based in Vietnam. So, for all the cases which Boyce Schiller has in Vietnam, they have raised about $30 million from a funder. So those kind of arrangements are also coming in other parts of the world where litigation finance has existed and of course is developing at a very rapid pace. I also do have another comment which I would like to take. No, so this is a question from Sarabjit Ghosh. He asks, have you seen litigation finance loans being structured into securitized assets, as we have seen in cases of loans of several types being securitized into bond-like securities? No. So these kind of arrangements, no, we've not seen those so far, and in fact, that would take the non-recourse nature away from it. Of course, financiers do secure themselves on adverse costs. So, for example, if a funded claimant loses the case, so not only the costs which the funder has funded, often arbitral tribunals go ahead and award adverse costs as well, which means that the claimant is liable to pay the cost of the defendant. We have seen funders take out ATE insurance, which is after the event insurance, in order to protect themselves from such adverse cost order. However, we have to keep in mind that this is an investment which is being done after extensive due diligence, which often includes taking prior opinions from barristers, from Queen's Counsel, from Senior Counsel, depending on the nature of the dispute, depending on which jurisdiction it is being contested in, depending on which jurisdiction it has to be enforced. Thus, a funder is making a very informed decision, and as opposed to taking a chance on a claimant. There is extensive due diligence, which often takes months, to conclude, in which, as I mentioned, there are opinions which are already taken, and then an informed decision is. Another very interesting comment from Sarabjit, it says how litigation finance could be used in the case of class action. Something which has actually been happening in the US for well, I would say a number of years. I don't even know when it all started. And contingency fee arrangements have also been prevalent in the US since always. So class actions are often there funded by litigation funders. In fact, that is one of the criticisms to litigation finance in the US, where they say that the presence of a litigation financier encourages litigation rather than discouraging, which is a complete opposite view taken currently in India, in Singapore, where we are talking about how litigation finance is promoting access to justice. However, in the case of class actions, like any other case, it is no different. A class which is being represented by legal representatives, by lawyers, can be financed by a litigation financier. When you speak about nuances of such deals as to what would be the return, that differs on a deal to deal, that differs on party to party, what kind of arrangements they negotiate. However, we do have a range, as I mentioned, that it's 25 to 35% of the total recovery, or for that matter, a 3x or a 4x on the investment.
Pranav, I had a question here. I mean, I
Sure.
wanted to hold this, but since you are already on this point, so I'm just going here. So when you say that this is one of the more riskiest asset class, and this is also one of the asset class with the highest returns, I mean, I would understand the risk and reward of asset class with reference to the others. Like you have to say if stocks are risky, stocks are riskier than bond. That way, right? You cannot say risky generally. So where would you put it? Like in a risk reward basis from the other asset classes in the spectrum, where exactly does litigation finance sits?
So Jyoti, as mentioned, there are several reports which have
Hmm.
been made on the progress of litigation finance as an asset class in different jurisdictions. So US, UK,
Hmm.
Australia, in fact now even Canada. Now there are several reports which have been made by industry experts which have done this research, and those reports suggest that compared to the classes that you mentioned, and compared to other investment classes as well, other asset classes as well, it is one of the highest performing for the last 10 years running for the UK for sure. I'm not too sure about the US. So I believe experts have already done this comparison in their report as to
Hmm.
why it is outperforming the other asset classes and by how much as well. I would be actually happy to share the report post this with everyone, or probably I can email it to you and you could email it to the delegates. These are available in public domain as well.
And another thing I wanted to ask, like, see, any asset class is going to give you a return based on time and space and country, right? So do you think that if we treat this as a distinct asset class, it's likely to give as much return, or the Indian returns are likely to be less? Why I ask you this, the places where you grow the litigation revenue, say like class action or high value regulatory litigation, your damage calculation norms in terms of how much punitive damages or future economic loss is being granted. I mean, those things are not really that evolved in India right now. So would it do just as good in India?
So Jyoti, that actually remains to be seen. Very, of course, you raised some very valid points. The time, the location are extremely important. There is a particular reason why global funders are still shying away from India. While they are watching India like a hawk, it's a very interesting market for them. Everybody can see the amount of litigation which India has, and of course, the number of such claimants who have good claims but are not able to pursue that litigation. It remains to be seen how it's going to perform in India, because of course there is a lot of judicial uncertainty, that increases the risk. And in fact, often in our interaction with global litigation financiers, this has been one of the challenges. As I mentioned right at the very beginning, that and in the identification of three core parameters, asset tracing might just be as important as the legal merit analysis. Of course, your case should be good, and that is step one to proceed. But asset tracing for an investor is extremely important, and this is exactly the reason that you mentioned. For example, not just India, litigation financiers, they tend to shy away from any risky jurisdiction. Like Indonesia is something which litigation financiers aren't interested in, simply again because of the uncertainty attached to that jurisdiction. A lot of comparison can be made to India as well. In fact, I think so 3 weeks back, there was an article about a case which lasted for 50 years. And I think so I had 7 rounds of litigation. It started in 1971 and has concluded now in 2021, probably finally. So there are these examples which obviously can be nightmares for any investor. So those kind of risks do exist. At the same time, as we have seen, and especially related to the arbitration space, there has been a lot of development which has happened. I would say right from 2012 when Balco came out, and how everything was divided between now pre-Balco and post-Balco. And again, as we all are aware, the significant amendments, the extensive amendments which happened to the Arbitration Act in the year 2015, and then further in 2018 and 2019, is something which is very encouraging as well. There are time limits now which are prescribed under the Arbitration Act, both for execution as well as challenging the award. The grounds have become limited. Certain judicial pronouncements which have come out of the Delhi High Court, the Bombay High Court, the Supreme Court have been very pro arbitrations. Those are very encouraging signs for someone who is looking to invest in an arbitration litigation, the cost of an arbitration litigation, because there can be now certain predictability onto the time which the court might take in terms of setting aside action as well as an enforcement action. Plus, at the same time, limiting those grounds of challenge has again been seen as something very encouraging. So there, I would say it remains to be seen, but currently the positive signs, like the ones I mentioned, the examples I mentioned, are outweighing the negative. That's why there is quite a lot of movement in this industry in India. Like I said, there are financiers who are looking to set up shop. There are financiers who are looking to raise money to set up shop in India. There have been cases of or there have been examples of Indian claimants who have already received funding from global funders. But of course, right now it is for cases which are seated outside India and would be enforced outside India. But Indian claimants are warming up to the concept of litigation finance. Global finances are looking at the Indian market as well. And currently, the encouraging signs, as I say, outweigh the negative signs. Plus, also a very important aspect is that the pandemic has affected everyone and continues to affect. It's still by no means it is at an end, and hence such an industry like litigation finance has tremendous scope to grow at a very rapid pace. Probably because now companies are understanding the advantages of litigation finance. So by no means now litigation finance is limited to only indigent claimants, or in simpler words, claimants who cannot afford the cost of counsel. Even well-capitalized companies are exploring the option of litigation finance simply to take certain costs off their books, simply to outsource the risks attached, simply to keep more working capital in hand. There are these advantages which are being considered by well-capitalized companies. So the litigation finance should do very well in India, and definitely will be increasing at a very, very rapid pace. However, there are certain reasons that the roots of litigation finance in India, as I mentioned, have existed since 1876. And then, of course, more prominently, we have seen the recent judicial pronouncements. We have seen, I took you through the state amendments made in CPC, which are not so recent, but they are in the 1975, I think so, and the last one in 1980s. So there is a reason why this has still not picked up. It has not picked up because of the uncertainty and because it has probably not been extensively examined in any of the courts so far. Hence, there is still certain uncertainty. There's a lot of uncertainty. There are still people who debate whether litigation funding, third-party funding as a concept is legal or not. However, I believe there is now a stand on that, at least if we go through these entire series, we go through the recent judicial pronouncement, at least that question should be now put to bed. But yes, there is tremendous scope. I do see another comment. So again, a very relevant comment raised by a very relevant question raised by Sarjeet. He asks, "Do I see the risk of too much money chasing too few deals, as we see in developed market private equity these days?" Again, not yet, because litigation funding industry, at least in this part of the world, is still at a very nascent stage. It remains to be seen how it's going to develop. So far, and contrary to probably some public belief, and I was coming to that, so far litigation funding deals, at least in our limited experience that we have seen, are limited to two types of deals. Either it is a single case, which is a big ticket dispute and primarily relates to, of course, industries which have those big ticket disputes. So as you can guess, construction, infrastructure, uh, oil and gas, these are the kind of industries which are seeing litigation funding deals because they have those big ticket disputes. Why do we say big ticket disputes? Because of course, if the claim is big, then there is enough money for everyone in it. But if the claim is small and your cost of fighting that litigation is high, then of course, both litigation finances as well as of course the clients are mindful that even if they are successful, the client might not end up with anything. Even litigation finances are very mindful of that. In fact, there is an unofficial kind of a practice which is followed in the litigation funding industry, which is that your budget to fight the case, that means your cost of litigation, should be up to only 10% of the total claim amount. So we call it a 1:10 ratio. The reason for that is that even if there is a settlement and you don't get the entire 10, you get about 8, there should be enough left for the client, because the client should not be left with the feeling that, yes, I was successful, but however, because I did this deal with the litigation financier, I only ended with pennies to the dollar. This has also been, in fact, interestingly, this particular point has also been examined in India, where it has been stated, again in certain judicial pronouncement dating to the 1950s, where these agreements are to be examined for this kind of a nature. In fact, again, I'm forgetting the case. I think it was in the early 1900s, where the court exactly examined this, that yes, litigation financing deals are allowed, but it shouldn't be something which is unfair to the client. So, for example, a litigation funding deal should not say, okay, the funder is going to take 85% or 80% of all proceeds, because that clearly is unfair. Right. I was, if there are any further questions, I would be happy to take those. Otherwise, I'll continue. I was talking about the development in India, and in fact, I was talking about two types of deals which we have seen so far in the litigation funding industry, which also includes deals for Indian claimants, in which I have also personally been involved. So big ticket disputes are one. So basically, it is a single case where the funder agrees to fund the cost of that particular case itself. And once that case reaches its conclusion, whatever the recoveries are, the funder is going to take a percentage of that recovery or take a multiplier on its cost. The other are portfolio deals. Again, there are two examples in the public space in which certain portfolio deals have happened in India. The last one was by Hindustan Construction Company, HCC, where they sold a portfolio of their claims as well as awards which were pending enforcement to a consortium of investors led by BlackRock Investments. The values that were disclosed were the entire portfolio was valued at roughly close to 5,000 crores, and it was sold for about 28% of that amount, or roughly around 1,700 crores, was what was reported. Similarly, I believe there was the case of Patel Engineering as well, in which 8 Capital acquired certain percentage in the subsidiary, but simply it was acquiring the outstanding litigations as well as the outstanding awards pending enforcement. So such portfolio deals are also on the rise. So we usually see these two types of deals happening in the litigation funding industry. Now, when we speak about these two deals and we try and relate these practically to India, of course, there are plenty of big ticket disputes. There is plenty of litigation in court. There are some enormous amount of claims which are pending in court, as well as at the same time there are these portfolios which can be with financial institutions, which can be with banks, which clearly are with construction companies like HCC, who are trying to sell it off as a portfolio. Basically, you're assigning your claim to the third party funder in order to balance your books. So there is definitely these two type of cases definitely do exist in India. Hence, the scope of litigation finance in India seems tremendous. It definitely seems to be on the rise. As mentioned right at the very beginning, I'd like to examine things practically. So in case there are any questions so far, I'd like to pause for a minute here, take any questions so far. Right. Now I want to move on to the second part of the topic. So the prospects of litigation finance in India. Yes, we have been discussing that, but let's talk about it with a special reference to international commercial arbitration. And why do we see litigation finance go hand in hand with international commercial arbitration? I believe it is obviously my personal view. I believe it is because of the reason of what Singapore did. And as I had mentioned, that Singapore in 2017 allowed litigation finance for only arbitration and arbitration related court litigation. Thus, litigation finance seems to be a development which is related to the international arbitration ecosystem. Singapore's reason to allow third party funding, and I can say this with some confidence, was this only that it has continued to strive in making itself as the most prominent seat of arbitration in the world, as or second most prominent seat of arbitration in the world, as reported in the Queen Mary survey, last Queen Mary survey. It has become extremely popular for, of course, Indian parties. So it is their attempt to continue being a hub for international arbitration, thus allowing third-party funding to arbitration and arbitration-related court litigation. Indian claimants in arbitration are on the rise. We have already seen quite a few examples. There are quite a few Indian councils also now who are working with third-party funders, and quite a few examples where Indian claimants are already being backed by global litigation financiers for their arbitrations which are seated in Singapore, for their arbitrations which are seated in London, for their arbitrations which are seated in Paris, for their arbitrations which are seated in New York, for their arbitrations which are seated in Hong Kong. And of course, where it is against a party from another nationality and another jurisdiction, where enforcement might be seen as slightly easier, slightly more predictable, in terms of time, in terms of resources, in terms of previous judicial pronouncements. Those kind of deals are definitely on the rise. Also, I mentioned it is no longer limited to only claimants who cannot afford the litigation, well capitalized companies, and for that matter, very interestingly, even certain Indian PSUs are exploring the option of litigation finance. I believe there hasn't been any disclosed deal of litigation finance relating to an Indian PSU reported yet or done yet. But however, I'm well aware that yes, more and more companies, including Indian PSUs, are exploring the option of litigation finance, at least for their international arbitrations so far. But as more Indian litigation finances are born, as this industry develops, probably global funders will set up INR funds. We would see this industry progress further. Speaking on that point, I wanted to touch upon another very interesting uncertainty. It's an interesting uncertainty. And I say this, I would like to explain this. It's still not clear if a global litigation funder was to back, let's say, for example, an Indian claimant in an Indian litigation with enforcement in India. He will he will fund that litigation. That means he would be funding an Indian counsel as well. Once, let's assume he is successful, he makes a profit. The uncertain part comes in as to how he will take those profits out of India. FEMA on that end is still not clear. Whether this will be a capital account transaction, whether this will be a current account transaction, many other related questions are still not clear. There are, of course, I would say, premier tax firms which are advising funders on such kind of structures. So these kind of uncertainties also have stunted the growth of this industry or held it back so far. These uncertainties can only be addressed, one, of course, if there is legislation, if the government steps in and decides to make certain regulations. This can be done through various forms. Or there is certain scrutiny by court in any particular case where then there is a precedent for everyone to follow. Till the time these uncertainties remain to be seen, they're still unanswered, they have to be addressed. And that is the reason why this industry hasn't grown at the pace compared to other jurisdictions where third-party funding is allowed. And in fact, certain other jurisdictions like Singapore, where it is still allowed for a limited purpose. It is only allowed for arbitration and arbitration-related court litigation. As mentioned, in India, there doesn't seem to be any restriction like that yet. Also, why we say with special reference to international commercial arbitration. In the year 2017, the Justice Sri Krishna Committee was formed and they submitted their report on promotion of institutional arbitration and the growth of institutional arbitration in India, and categorically mentioned this point that third-party funding and allowing third-party funding expressly will further fuel the growth of international commercial arbitration in India at a faster pace. Also, institutional arbitration in India at a faster pace. Institutions have recognized the concept of third-party funding. SIAC had issued a guidance note where it gave the power to the tribunal to order disclosure of third-party funding agreements. ICC in the year 2021, in the latest set of their rules, have now made it mandatory disclosure of a third-party funder in an arbitration. HKIAC has, in its last set of rules, has again expressly made it mandatory for parties to disclose the involvement of a third-party funder. Now, these jurisdictions are already quite a few steps ahead of India, and I think so. It would be a good idea for India to take some guidance there. Speaking about the point of disclosure in litigation finance, and again examining it practically, Why is disclosure important in third-party funding deal? Why is it important for a party to disclose involvement of a third-party funder in their matter? Is simply because conflicts of interest, certain conflicts uh, have to be avoided. For example, it's like I mentioned on one of the comments which were there, that LCM, for example, is a listed funder in London. It's very much possible that an arbitrator or a member of a tribunal or arbitral tribunal is a shareholder of that particular company. Thus, that gives rise to a conflict of interest. Similarly, I was talking about the process of due diligence that these funders have, and where people like me also come in and we do our preliminary due diligence. The funders have their own teams to do their due diligence, of course, made up of lawyers. At the same time, they also have investment committees, which are made up of senior practitioners, senior arbitration practitioners, certain QCs, who help analyze the case for the funder and give the chances of success to the funder. It's very difficult to quantify, but often funders take that opinion from a person who has an experience of sitting in such cases as an arbitrator. So the conflicts need to be cleared, and that's why makes the disclosure provisions extremely important in funded deals. Again, a very interesting comment from Sarjeet. Thank you. He asked me, do you think litigation finance could be marketed to institutional investors under the ECG basket, giving a social justice spin? Indeed, it can definitely be marketed to institutional investors even without this spin. At the same time, institutional investors are definitely going to enter the funding space. In fact, it does go back to one of the comments which probably Nagaraj had raised, which was how LCM is. So certain funders, so LCM not particularly, but like for example, I took the example of Innsworth, which is backed by the Elliott Group. Similarly, there are number of funders in the US who are backed by HNIs, who are backed by family offices. People are looking to invest this in like an asset class, so they are setting up those litigation funding arms. So why only under the ECG basket and why only giving it a social justice spin? It does, there is no denying that fact. It does serve a noble purpose. It does level the playing field. It can avoid the David versus Goliath situation. And for that matter, when I speak about India, it is no secret one of the worst but most common used strategy in Indian litigation is delay in court. If a respondent now knows that the claimant is backed by deep pockets, there is no point of delay. If he's going to lose after 5 years, 10 years, 15 years, you often see that they decide to come to the table much faster than seeing the entire process. In fact, statistically, more than 90% of litigation of funded cases which are backed by funders go into settlement. They don't actually see the entire length and breadth of the legal process. At the same time, also very interesting statistic is that, and why I say they take a very informed decision. There is unofficial statistics available where it does state that a funder only funds 1 out of 35 to 40 cases which cross their table. That means we are talking about a conversion percentage of 2.5%. That's why these deals are done after thorough due diligence, and hence I have tried to relate it back to the concept of disclosure, why the disclosure is important, how people can be involved, how these deals are structured. I think so this would be a good point for me to stop again and ask if there are any questions, if there are any comments which I can take. post which I would foray into litigation finance as a career option for lawyers, for upcoming lawyers. But before that, any particular comments or any particular questions on how these deals are done, on the structure, on certain jurisprudence which exists, I would be happy to take those.
Okay, Pranav. So while you are on this as an asset class, so I have this question that is it actually an asset class open to a retail investor, or is it somebody with deep pockets who can enter into this area? That's one. The second question is we actually do have a kind of gray market of litigation finance in India, which is an unofficial, informal kind of market that have existed forever. Like if you go to the motor vehicles where the quantum was very small, and or land, Section 24 of the Land Acquisition Act, where the quantum was not small. I'm told the whole Malcha Marg Road is actually under litigation. Right. So is there some way we can sort of bring this, like sort of have a convergence of this gray market with the more formal channels that are emerging now?
Thanks, Surajyoti. Very interesting. Both questions. I'll take them one by one. Speaking about India, in fact, there used to exist a crowdfunding platform by the name of Advocate, and I think so. It's the same people who are now trying to establish what would be one of the first, and have I think they have already established what would be one of the first specialist litigation funders in India by the name of Legal Pay. As I mentioned, I know that it's the same people who had developed this crowdfunding platform called Advocate, where, as the name suggests, they were taking money from the public at large and investing it in, I believe, primarily consumer court cases, which were low-level disputes, which were lesser, I would say, comparatively, not big ticket. So when you ask me that question, that whether it is for individuals or it is for deep pockets, it is for institutional investors, it depends. So this crowdfunding platform clearly was trying to give this investment opportunity to individuals as well. It was trying to make this a market, like, for example, in fact, in this last 1 year, last 1.5 years, we've seen the share market go up. We've seen commodities go up. We've seen so much investment we made in crypto. So of course, that I believe that was the purpose, that it was to enable even individuals to invest in litigation finance as an investment, as an asset class. However, I believe Advocate doesn't exist anymore, and they have, as I mentioned, they have established what is probably one of the first Indian domestic litigation funder by the name of Legal Pay. So very interesting development there. I wouldn't like to speculate on the reasons as to why they changed from a crowdfunding platform to a specific litigation financier on the I would say pretty similar to the litigation financiers globally. Probably as a crowdfunding platform, it wasn't so lucrative. Secondly, litigation funding deals primarily are for big ticket disputes, where international disputes cross jurisdictions, where you do require international lawyers. We are well aware that, for that matter, even magic circle firms like Clifford Chance, they are not cheap. So it is very difficult to afford lawyers who charge in excess of $1,000 an hour. Hence, the big ticket disputes are more lucrative for the litigation financiers because there is enough in the pie for everyone in it. Now, to back such lawyers and to invest in such cases, I had also mentioned that we try to keep the budget up to 10% of the claim amount, right? So that means your legal fees that you can spend on a case, hypothetically, let's speak with numbers as an example. If it's a $50 million dispute, the legal budget, which also not only includes the fees of the lawyers, it also includes the fees of the experts, it also includes the fees of the tribunal. In case it's an institutional arbitration, it will also include the fees of the institution. So all those costs shouldn't exceed $5 million. Right? Now, $5 million is something which is, I would say, a big amount, and hence it has primarily litigation finance primarily has seen the development with institutional investors either setting up their own litigation funding arms or backing specific litigation finance companies.
So one more question I have, like this is actually a response to what you said. Like it seems to me the problem with having retail people or a pooling process, like say having a listed company, is that you are probably not able to disclose these deals on your balance sheets because of confidentiality issues, and in which case you cannot seek funding. Is that an issue?
Sorry, Surjyoti, I missed last 10 seconds. Could you repeat your question?
Yes. So, for example, if you have like 10 litigation financing, you are a listed company and you have like 10 deals on your book, you won't be able to disclose it because of confidentiality issues. So, this confidentiality basically acts as a high transaction cost, which reduces the retail participation in it. And it will always be like that.
No, so absolutely. I still didn't get the question part in it, but you have
Okay.
the disclosure is of course these companies are listed, and in fact, like I can give you examples of Burford's accounts. Burford is one of the biggest litigation funders in the world. It's a US based fund. Burford's accounts are obviously available in public domain. Similarly for LCM, how they disclose it in, and it's for everyone to see, is that they uh, they disclose how much of the amounts are currently under investment, not by region, not by industry, not by anything. It is just an amount that these, for example, $1.2 billion, I think so was the last reported, which was, so they have $1.2 billion worth of commitments which they have made to lawyers for ongoing litigation. Now, if how is it lucrative for the shareholders? Is of course you're looking at a 3x from those $1.2 billion expectedly. So hence, but sorry about the confidentiality.
No, so I was thinking that this is something which would work with a heavy degree of confidentiality. So in a listed entity, you will have this disclosure requirements which would be difficult to accommodate. So this is a structural issue with the industry. Is my perception correct necessarily?
I would say yes and no. Whereas yes, definitely confidential nature of such deals, of such proceedings as well. They are as much as possible. They are, everybody tries to cover it. For example, there are even in the process of litigation finance, as it starts right from the very beginning. As we are aware, it is extremely important to not just preserve confidentiality. It is extremely important to not break privilege. You are talking with the lawyers directly. It is very important to keep that in mind, that you are not breaking privilege, you are not breaking the chain of privilege in any manner. So, of course, it is done with a very high degree of caution. One of the first steps, which, for example, even us at ELF Partners, before we take on a case, one of the first steps that we do is that we try and sign a very watertight NDA with the client or with the lawyers who are referring the case to us. Similarly, if any claimant or any lawyer was to go directly to the funders as well, it is step one that there is an NDA in place. Now, when it comes to these listed companies, like you mentioned, and their disclosure obligations, which of course is upon them, it is done on this manner, like I mentioned, that they would mention how much of money is currently under investment. Certain companies, they do declare by region. Certain companies might declare it as per the industry as well, but very, very few are those. But primarily, it is just the total sum and not on a breakdown of a case by case basis. I'm not too sure how they do it internally, probably how they are circulating it amongst themselves. But yeah, when it comes to the disclosure obligations, which they have to abide by, at the same time, they are preserving the confidentiality as well. Few things that are probably started to give away is I would say things like this. Like I mentioned, there are reported agreements now between funders and law firms for certain litigations which are either again categorized by industry or by jurisdiction. Like I gave the example of Boyschiller for Vietnam. There is similar, I believe, a funding agreement in place for CMS, which is again a global law firm traded in UK. They also have an agreement with one of the funders for their industry specific cases. So certain, I would say, and this is again just my personal opinion, I would say these things are probably giving few things away. Now, if I do know that Boyschiller is representing XYZ, I if I'm and I'm on the other side, the first thing is going to be my assumption would be that probably it's because of the fund. So those kind of, I would say, that is probably breaking the confidentiality slightly. The disclosure obligations which the companies have to abide by, that is no hindrance to the confidentiality. However, at the same time, because there is such sensitive information which everybody is dealing with, everybody is taking all steps which probably they can to preserve confidentiality as well as preserve privilege.
So I had a follow-up question about the gray market, because you see that we already do have some kind of funding informal agreements. So can we sort of mainstream them? Is there some way, or
So
they will have to just go?
I would. It's just a suggestion. I'm not too sure about the gray market. I'm
Mm.
not too sure. Talking about contingency fee arrangements, which lawyers are probably making with their clients. Uh, yes, they are not allowed. It's a disbarable offense. Bar council rules are pretty clear on it. All the judicial pronouncements are pretty clear on it. As well as the Advocates Act is very clear on it. However, I do understand the question, and I do what you're asking is the marriage of this gray market sort of culminating and it becoming official. So contingency fee arrangements, yes, while they are not allowed, it is a question which has attracted a lot of attention in the recent past. Uh, there are examples in the US which contingency fee arrangements have existed uh, since, I would say, always. That's why the lawyers there at times they get the tag of ambulance chasers as well. Uh, so yeah, it's a question which currently in India needs to be answered. Litigation finance is not an alternate to contingency fee arrangements at all. Litigation finance is a separate industry. It's a separate practice, as it is there in the name itself. Third party funding, a party unrelated to litigation. In fact, it totally goes to the definition of maintenance if we talk about champity and maintenance. That's why those doctrines, them not being applicable to India is extremely important. Or for that matter, any jurisdiction where third-party funding is now either developing or has come into existence. It, it, it is the definition of maintenance. It is that you are encouraging litigation in order to profit, make a profit, monetary gain yourself. So yeah, it is very separate from contingency fee arrangements. However, I mentioned there is a case which is pending in front of the Supreme Court where the party entered into a contingency fee arrangement with their counsel, who is not a lawyer but is a chartered accountant, but represented them in the arbitration, which was a construction law case. So hence he was able to prove those damages to the tribunal. He was able to get a favorable award. That question, I believe, will be examined by the Supreme Court and that's when you could probably again expect some movement for this question to come up again. If contingency fee arrangements will ever be allowed in India at all or not. But third-party funding cannot in any way regularize contingency fee arrangements. These are the two separate concepts altogether. In fact, in the UK now, there are damage-based agreements which are being allowed. So as this development keeps on happening in other jurisdictions, there is talk about contingency fee arrangements or examination of contingency fee arrangements in Singapore. There is talks about that. There might be some development. So yeah, as probably these questions are answered in other jurisdictions, I expect India to follow the practice and these questions being answered as they come up again. Right. If there are any further questions, I would be happy to take those. Otherwise, I'll foray into and speak about uh, litigation finance as a career option, and probably I could give an example on how I landed up here myself. Okay, right. I do have a comment here, so I'm just reading that. I'll read it out loud. Part of the value add of private equity to corporations they invest in is the expert networks offered by PE to the management teams. Is a similar analog seen where an expert network may be offered by the litigation financier to the claimant, uh, to a claimant party other than just a well-funded legal team? Very relevant question. In fact, this reminds me there was another aspect which I should have covered, is what kind of control do litigation financiers exercise on a matter? Are they in charge of choosing the counsel? Can they fire counsel? Can they bring in their own teams? Or for that matter, the expert network, which in the comment just raised by Sarji, can there be what is the role of the litigation financier? It is a very relevant question. Why? Because I have been speaking about how it is an investment for them, and of course, how they're doing this for a profit. So, shouldn't they be allowed to exercise all control in order to ensure that their profit is maximum, in order to protect their investment? I'm asking this question out loud and just giving something to think about, and we could probably have a few more comments on this. However, practically speaking, and how it happens in practice, is that funders don't exercise any control on the proceedings. They're available if guidance is needed. They will never say no to that. However, client's choice is supreme. So client is definitely entitled to bring in their own lawyers. Funder may want to add a co-counsel, again, in order to protect his investment. Similarly, the strategy which a lawyer proposes, the funder does not comment on it or meddle with it. He basically has to agree with that strategy while he's doing his due diligence, that this is the strategy being proposed. Is it good, bad, ugly for them, whether they accept it or they don't accept it? They don't exercise this control. However, there are always ifs and buts in everything. The fact that whether a funder is to finance a case or not, the decision whether a funder is to have is going to fund a case or not, at times is of, or rather is often influenced by who the legal team is, who is the counsel representing the client, because it becomes an important aspect for them to see whether they are happy with the team, whether they would like to change it. If they would like to change it, they're technically going against client's choice, which they don't want to do. So there is this, there are no regulations or rules in this, even for that matter in other jurisdictions. Totally depends on funder to funder. Mostly funders don't interfere with the legal team. They don't interfere with the strategy. Once they come in, they manage the litigation only in terms of the costs. They monitor the costs. They monitor the costs being incurred at every stage and disperse that accordingly. So they practically are not exercising. However, the question is for everyone to think about, that how does otherwise he's supposed to protect his investment? In fact, there is this question already asked by Surajit. What kind of protection will they have against, say, negligence by the client? Once they enter into a funding agreement, these funding agreements, like all other agreements, are quite extensive. They list down all the covenants. They list down all the representations the parties have made. They list down what all obligations the parties are supposed to do. So the arbitration funding agreement is the protection actually they have. Apart from that, as I mentioned, it depends on funder to funder. Certain funders might not change the legal team, but would like to bring in a co-counsel. Certain funders keep a hands-off approach completely. They only get involved with the cost aspect of it, whereas certain funders, their decision is influenced by, or one of the factors in their decision whether they want to fund a case or not is whether there is who is the counsel for the parties. Another question, and again, I get another point which probably I should have covered. Question is, will the funding agreement be before or after the discovery? Good, great question. Actually, funding agreement or a funder's involvement can be brought into a case at any stage. It can be brought into a case right at the inception. It can be brought into the case while probably just before the final hearing. It could be brought into the case after the award. It could be brought into the case while execution proceedings are pending, or even while execution proceedings are on. It all just depends at what stage the funder is going to come in, and they are free to come in at any stage. The cases that we have done so far, we have done it at different stages. We have helped clients right at the inception. So that means I'm talking about where there is nothing, right? There is no notice of arbitration, nothing has been initiated. The dispute has probably just arisen, and they are evaluating whether they should or they would want to go ahead and contest this litigation or not. There are those kinds of clients who want to have a litigation financier present right at the very beginning. Otherwise, they will not be able to pursue. There are those who, at some stage in the process, have started feeling that it's better to get a litigation financier in because I've already incurred certain costs. So I don't want to incur further costs, and my claim is big enough to get a funder in. Similarly, funding arrangements also can be made. If you can recall, right at the very beginning, I had read out the definition of third-party funding as per the ICCA Queen Mary Task Force, which says that a third party can fund whole or in part of the litigation cost. So in part basically means this, that we have seen funding arrangements being made between the client and the funder, which is only for, as an example, till the stage of interim measures, till the stage of only securing interim measures. There are funders who have agreed to fund only the costs up to interim measures. There are funders who have agreed to fund only the execution proceedings. Once the claimant is successful, they have agreed, and they say that, okay, once you reach the execution stage is where I would come in. And at the same time, there are also there are now agreements like this where the funder pays 50% of the cost of the litigation, while the client continues to bear the rest 50%. So those kind of funding arrangements have started coming in. So it not necessarily before or after discovery, it can be done at any stage. However, the disclosure obligations should be kept in mind. If a funder has been involved right from inception, before even the tribunal is formed, before even the notice of arbitration has been served, before basically commencement of any kind of any kind of action, it would be important that the moment the tribunal is formed, the moment the tribunal is appointed, that the party which is being backed by a funder should disclose. At the same time, if it is on an ongoing proceeding, then you have to disclose to the tribunal. Then it can give rise to those complications that I had mentioned, that a funder comes in and one of the members of the tribunal is probably a shareholder. He would become conflicted. It can derail the proceedings slightly, because of course there has to be a replacement of the arbitrator. So those are the practical nuances which can hamper involvement of a funder, can hamper an ongoing case. Those are the practical difficulties which one might face. But yeah, it is just important to keep that in mind. And when we are talking about this practically, and all of you would either be practicing law soon or are already practicing law, you can just think about it. Take a moment and think about it like this: that if you are the counsel for the respondent, and now you know that the claimant is backed by a third party funder, you know the position of your case. What would you suggest to your client, or what kind of impression is that going to make on you as well as the tribunal? There is a third party now which is backing the claimant after doing extensive research, believing in the case enough that they will not just be successful, they will be successful enough to make a profit. It does have an impression on the tribunal, but naturally, it does have an impression on the counsel for the respondent as well as the respondent himself. I had also mentioned that one of the worst but yet most common use strategy is delay. So yeah, there is no point in delaying if you're backed by deep pockets, uh, or if you know that the other side is now being backed by someone who is making an investment and is going to protect his or her investment to the fullest. As I just see a question here from Shreyansh, he asks, how will the tribunal know that it is being funded by a third party? I had mentioned in the middle that there are disclosure obligations now. Uh, for example, SIEC has given this power to the tribunals to order that disclosure, whereas ICC rules, the most recent one in 2021, which have just been launched in 2021, has now mandated such disclosure. The moment a third party funder is involved, the party has to declare it, disclose it to the tribunal as well as to the other side. Similarly, HKIAC rules, other arbitral institutional rules, and I believe in the UK, because there is no statute, there has been certain judicial pronouncements where involvement of a funder is mandated to be disclosed to the court as well as to the tribunal. So yeah, that's how a tribunal will know that it is being funded by a third party. In case you don't make this disclosure, then of course you are opening yourself to complications at enforcement stage or post award. It can be one of the grounds of setting aside. So yeah, you will be opening yourself and your client to such kind of risk. Fine. Any further questions? Right. So I'll quickly get a word in on litigation finance as a career option. It's very interesting, and of course, it's like I mentioned, we've just gone through examining how relevant it can be in India. I still strongly believe that litigation finance as an industry will grow at an exponential rate at a very rapid pace. We are going to see a lot of movement happening in India, in neighboring jurisdictions, in Asia, on litigation finance. The COVID-19 pandemic has only accelerated that growth and will accelerate it further, because there are advantages of the litigation finance industry which cannot be ignored. That does mean that we are expecting more and more litigation funders to establish themselves in India. There can be new ones, there can be existing ones, there can be global funders who I mentioned are looking at India very closely, probably thinking about setting up specific funds for India, while even they have the uncertainty of FEMA and the RBI regulations. They are looking to set up specific INR funds, which would be based in India, fund Indian cases only, remain in India. Does it, and I mentioned that the due diligence process for all these funders is something that they do not compromise on at all. In fact, the funders that we interact with as well, we speak to people who were either in global law firms doing litigation, doing arbitration, have significant experience under their belt, because those guys are the first ones who analyze a case. So you're still the counsel. You're still analyzing the case. You're still thinking about strategy. You're still thinking about whether the strategy which is being suggested is good, bad, or ugly. You are thinking about all that. However, you are now not the one who's going to implement that strategy. So that is a difference between a lawyer practicing in private practice, whether with a firm or doing litigation in court, and a lawyer who is working under an employment with a funder. They're both doing the research, they're both analyzing strategy, they're both instrumental in making the strategy as well. However, there is one who's going to implement it, and there is one who is just watching it, analyzing it, and giving his opinion whether this is a viable investment or not. So you can think about it like this, that it's not, litigation finance is not just the practice of law, it is also the practice of finance. Because now you are looking at a case, not just as a case, not just as a lawyer, you're looking at a case as an investor. I would probably give an example as to how I landed up in the litigation funding industry is as Surajyoti also mentioned in his introduction, and as I told you, I started my career with Clifford Chance in Singapore. I was doing international arbitration. It was a tremendous opportunity for me to be learning from probably the best, one of the best, few of the best people in the trade there. I got the exposure of doing different institutional arbitrations under different rules, SIAC, ICC, LCIA, ICSID. So that was a fantastic experience for me. And of course, I was doing those cases as counsel. Post that, I joined SIAC, where I was in charge of the South Asia desk. I was heading the South Asia desk for SIAC. However, I wasn't practicing anymore, and it was, let's say, pretty much my job to educate the market on institutional arbitration, the practice of institutional arbitration, and of course, then by extension, the use of SIAC, the popularity of SIAC, the process of SIAC, how easy or difficult it is. Thus, I was keeping very, part of my job, I was keeping very close tabs on all developments related to the arbitration space. And in 2017, the most talked about development related to the arbitration space, at least in Singapore, became third-party funding. What my company does, what at ENF Partners, what we do is we are consultants. We are not funders. We help claimants find funders for potentially good investments for them. So basically, we are helping both parties. What we try to do is add a bit more value to it by analyzing the case ourselves first. We have a team of lawyers who analyzes the case internally. We have a panel of barristers from UK, from Singapore, from UK, from India, senior advocates, as well as QCs, senior counsel, who help us in the legal analysis. We work very closely with experts in the industry, the EYs, the PwCs, the FTIs. We work with them for quantum analysis, and we have a panel of asset tracers with us. We do this initial due diligence, and then we present the case to a funder, stating that, yes, we have looked at it. We think this is a potentially good investment. It's a viable investment opportunity for you. And then, of course, they start their process of due diligence. It is a finance deal which cannot be done without the help of lawyers. So, of course, it's for someone, it's a great career option for someone who is probably thinking about corporate law, but is more attracted to litigation. So here you are involved in litigation, but actually you probably have a life of a corporate lawyer where you're not going to court. What I mean between the difference between a litigator and a corporate lawyer is that, yes, one is going to court, one is not going to court. So yeah, you're probably leading the life of a litigating lawyer, but in terms of the lifestyle is a corporate kind of a lifestyle. So it can be a great career option as this industry grows, because you're very much in touch with the law, you're very much in touch with the developments, you're very much in touch with the strategies, but you're not the ones implementing it. That being the only difference. So yeah, it's going to be a great career option going forward. In fact, I am forgetting the name of the funder, But in UK, there is one funder. Probably it was Augusta itself, or, or I maybe Woodsford. Uh, I'll try and confirm that. But they have started taking trainees like law firms. So that is a very interesting development for this to be a career choice. So I believe a lot of you would have done that research for yourselves, or probably would already know about the process. That if you join a global law firm, for example, a UK magic circle firm like Clifford Chance, or for the matter, like Sherman, like any other global law firm, initially you get a training contract for 2 years, and then you qualify in a particular area, and then obviously you qualify as a solicitor if you're working in a UK law firm. So there is a training contract. A funder has now started taking trainees. So like the law firm, there would be fresh graduates who would be doing a 2 year training contract with the funder, and then probably it might convert, it might not convert, like how training contracts with law firms work. So clearly, funders are also looking as developing this as a career option for fresh graduates. It's not necessarily only for seasoned or experienced litigators or experienced arbitration practitioners. They are trying to do that right from the very beginning. They are taking fresh graduates in. So yeah, this as a career option is clearly developing at a very rapid pace. All right, so I have a question from Nidhi. She asked that what, in my view, are the immediate policy changes slash clarifications that I think could help jumpstart litigation funding in India? Very relevant question, Nidhi. We have been thinking about this while we are a Singaporean company. Of course, I have my roots in India. India is a very important market for us. Uh, we have been thinking about this. We have a few suggestions that we are working on, but I believe that in between I had mentioned this, but probably not at length. The government needs to step in. So, for example, when we see and we can equate, we have to equate the growth of a development, the growth of an industry with something, right? So, even if we just currently think about this, and as the topic for today also suggests, the prospect of litigation funding with special reference to international commercial arbitration. If we just try and see how international commercial arbitration has developed, how institutional arbitration has developed. I know the stats for SIEC quite well since I was with them till about 2 years back, 2.5 years back. I also do know the stats of ICC quite well. What is clear from those statistics is that yes, Indian parties have started using institutional arbitration as an option in the last decade, and it has seen that growth. Really, the numbers are skyrocketed. SIAC itself went from 270 odd cases to 670 cases only from Indian parties. They're managing 1,000 cases right now, approximately. So 200 total cases in the year 2012 to 600 cases only from Indian parties within a span of 8 years is fantastic. Now, if why I'm equating this to institutional arbitration is because we have been talking about third-party funding as a development related to arbitration, and of course with special reference to arbitration. We can easily equate the growth of these two industries or these two practices, these two developments. How institutional arbitration grew, or primarily when it started growing, was because of SIEC's presence in India and of course Singapore promoting itself very, very strongly. Most importantly, and just breaking it down very simply, only once the market was educated on the finer aspects, on the finer points, on the finer features of institutional arbitration, they got the confidence to use institutional arbitration in their contracts. Similar would be the growth, I believe, in my view, charted by, it should be the path similar to the path as charted by institutional arbitration. Third party funding, litigation finance will only grow once people are aware of what it is, how it works, what are these deals, who are these players, who are these investors, what have they done so far. Currently, we are still we are still struggling with the question whether third-party funding is legal or not. So first and foremost, that question needs to be answered conclusively. That's why I say the involvement of government, I believe, is very important to bring in certain regulations. It will also fuel the education aspect of it. It's going to help people understand what third-party funding is. Again, if I have to draw a comparison with arbitration, 2012 was, I would say, the year in which the arbitration regime in India changed. We still call it a pre-Balco and post-Balco phase. 2015, it again changed further. I was, in fact, I was extremely lucky and thankful to the government to have introduced the amendments to the Arbitration Act on 23rd October 2015. I say this, I am thankful because personally, it really helped. I had just joined SIAC in August 2015. And because of these amendments, people started talking about arbitration so much, it made my job much easier in terms of educating the market. People were already talking about it. So similar, I believe, is going to be, or it should be, that there is a growth like that, where not just one or two stakeholders, all stakeholders involved need to come together. And yeah, we are trying to suggest a few things which would probably help grow this, bring in certain policies that I believe is what is going to help really help this grow. I do have another query. Yeah, absolutely. So Sid Sharma here, he's asked that, is there any legal hurdle in acquiring the litigation in totality rather than just litigation financing? Wouldn't the investor be safer just outrightly buying out the arbitration award rights to obtain? It depends. It depends. It totally depends. It's not a question of safety, actually. But yes, these kind of deals do happen. I had given the example of HCC, in which they did sell a portfolio of their claims. So what that meant was that they have assigned their rights under the claim to the third party now, and third party bought it. Those deals are slightly different because, of course, you are. If I have to speak about them practically, what happens is that yes, you're going to determine a price to buy out that particular case, that arbitration, maybe a portfolio. You would be probably buying it pennies to the dollar, which would be, for example, let's say hypothetically speaking, you buy out an arbitration in which the claim is worth 100 million, you buy it out for 20%, so you bought it for 20 million. You still have to go ahead and fight that litigation, right? You've just bought the claim. You still have to successfully fight it. Let's assume that there is another 5 million cost of fighting it to the extent of enforcement. So he spent about 25 million in acquiring that arbitration outright. Major chunk of that money has gone upfront, and of course, yeah, he will make about 75 million on it. So, but he's already invested 20 million, as opposed to litigation finance, in which in this particular case itself, in taking these numbers itself, if he funds $5 million as the fee, he stands to make about 25. So he's technically tripled. He's quadrupled his investment as compared to the other example that I just, with these numbers, he would be actually only tripling his investment. So you see, he's actually made more money in financing the litigation rather than buying it outright. Of course, these are just hypothetical numbers. This is just an example, just to give some context to and compare these two types of deals. Okay, we are almost out of time as well, but I'm happy to take questions. I love discussing this subject. Happy to take any questions, even on the last part I spoke about the career option. Please feel free.
No, so Pranav, what I understood about the career option is that it's still a somewhat unstructured way. You have to, you can try a trainee contract, but there's no way to become a litigation financer. Like you have to find your way, right? Is that the case?
Absolutely, Surajyoti. And I think so. The education in litigation financing is still, because the industry is so nascent. So I don't think so. There are any courses on that. What we have taken guidance from is, yes, how the teams of these funders are made up. It is definitely a mix of lawyers as well as people with finance background, people who have been investment bankers in the past, who know how to analyze the cost benefit analysis between that. And of course, lawyers are extremely important. They are an integral part. In fact, you take the case of any global funder, it is currently being run or being managed by probably someone as senior as a partner in one of these global law firms who's made a career change and joined a litigation financier, giving up private practice. So for fresh graduates, that's why the only example I currently have is of the training contract. That also I know only one funder has done it. So there's still a lot to be seen, a lot to be desired. But the funding teams, the global funders, the teams are definitely made up of lawyers. It just depends that they might need someone a fresh graduate, or of course, ideally someone who at least has some experience under their belt in terms of analyzing the cases, because that is a very integral practice for the litigation finance industry.
Okay, so here we have a very interesting job for tomorrow, because you see, I'm sure that in next 20 years, like the legal profession we entered, it's completely morph into something we don't recognize. So you have to just find out the growth opportunities and just structure yourself in.
Absolutely.
So I think that's all we have time for today. Thank you, Pranav, so much for your very interesting presentation, and more so because of taking so much time to interact with our students. We would definitely like to have you on the campus once we open. It has been an extremely informative session. I hope that we can take this forward in form of a conference or something bigger, because this seems to be a really promising line of work. This can revolutionize litigation. So I thank the students for joining us, and I also thank our IT team for making this possible. So thank you, everybody. Good night and have a good day.
Thank you, Subrajyoti. Thank you, everyone. I'm sharing my email address on the chat, so feel free to contact me directly. If you have any questions, I would be happy.